A shakeup of former President Trump's legal team after he was indicted on federal charges. Sources tell ABC News 2 of Trump's attorneys have now resigned. This after a grand jury indicted the former president on charges related to his handling of classified documents.
Donald Trump has not stood up in a courtroom and verbally confessed to committing crimes. There was no cinematic moment where he looked at the judge and admitted guilt. His lawyers did not dramatically abandon him mid-trial in front of flashing cameras. That image belongs to movies and viral thumbnails, not real courtrooms. But what is happening is far more consequential, far more damaging, and far more revealing than any single spoken confession could ever be. The evidence itself is doing the admitting for him, and the people who once protected him are steadily disappearing the closer they get to the truth. What we are witnessing is not a confession through words, but a confession through documents, recordings, sworn testimony, financial records, and the statements of people who carried out Trump's instructions and are now under oath explaining exactly what happened. At the same time, we are watching a quiet but unmistakable collapse of Trump's legal defense network.
It is an outright resignation. These were lawyers that had been by Donald Trump's side, had been working this case for the better part of a year. Charges come, they stepped out. And I think that also has to do with the fact, this is going to be surprising, Diane, there was infighting within Team Trump. We've heard that before.
Lawyers are not storming out of courtrooms, but they are leaving in waves, resigning, withdrawing, flipping, or being indicted themselves. That pattern tells a story every bit as powerful as a courtroom admission. To understand why this matters, you have to understand how criminal cases are actually built. Prosecutors do not need a defendant to confess. Confessions are useful, but they are not required. What prosecutors need is proof, and in Trump's cases, the proof is abundant. Paper trails do not forget. Bank records do not get confused. Audio recordings do not reinterpret themselves later. When you combine those with testimony from insiders who were present during the events in question, you end up with something that functions exactly like an admission, even if the defendant keeps saying, "I didn't do it." The Manhattan hush money trial is the clearest example because it already reached a verdict. Trump pleaded not guilty to 34 felony counts of falsifying business records. His public position was simple and absolute. He denied knowing about the hush money payment to Stormy Daniels, denied directing Michael Cohen to make it, and denied falsifying anything.
Was it hush money to stay silent?
Yes.
I am ashamed that I chose to take part in concealing Mr. Trump's illicit acts rather than listening to my own conscience.
His lawyer argued that Cohen acted on his own and that the payments recorded in Trump's business books were legitimate legal expenses. That was the defense. It was clean, direct, and completely undermined by the evidence. Prosecutors presented a methodical, document-heavy case showing exactly how the scheme worked. Michael Cohen testified under oath that Trump personally directed him to pay Stormy Daniels $130,000 in the final weeks of the 2016 campaign to keep her silent.
In July, Cohen released audio from a conversation with Donald Trump that he secretly recorded 2 months before the 2016 election. The two appeared to be discussing payments to a former Playboy model who said she had an affair with Trump.
When it comes time for the financing, which will be...
Listen, what financing?
We'll have to pay you. So
Don't pay the kid.
No. No.
Jurors heard recordings of Trump discussing the payment with Cohen. They saw bank records showing the initial payment and the subsequent reimbursements. They saw internal Trump organization documents showing how those reimbursements were falsely labeled as legal fees, broken into monthly payments, and grossed up to cover Cohen's taxes.
It took a New York jury just over 9 hours to convict former President Donald Trump of 34 felony counts of falsifying business records. The prosecution was able to prove Trump tried to hide damaging information from voters ahead of the 2016 election, ordering his former attorney Michael Cohen to pay adult film actress Stormy Daniels $130,000 in exchange for her silence about their alleged sexual encounter.
Trump claimed ignorance, but his own lawyer testified he gave explicit instructions. Trump claimed the payments were legitimate, but the documents showed deliberate falsification. Trump claimed Cohen acted alone, but the recordings contradicted that claim. The jury did not need Trump to admit anything. The evidence spoke clearly enough on its own, and the verdict reflected that reality. guilty on all 34 counts. That outcome matters because it demonstrates a core truth about Trump's legal exposure. His denial strategy does not erase evidence. In fact, when a defendant denies conduct that the evidence overwhelmingly proves, it often makes things worse. Jurors are not just evaluating whether a crime occurred, they are evaluating credibility. When they see a defendant flatly deny something that documents, recordings, and multiple witnesses confirm, they conclude that the defendant is lying. And once jurors believe a defendant is lying, they become far more willing to believe the prosecution's entire theory of the case. The same dynamic appears in Trump's other legal cases, even though they have not yet reached trial. In the classified documents case, Trump has repeatedly claimed that he did nothing wrong, that the documents were his, that he declassified everything, and that he fully cooperated with investigators. Those statements exist alongside an indictment that paints a very different picture. According to prosecutors, Trump retained highly sensitive national security documents after leaving office, refused to return them when requested, allegedly showed them to people without security clearances, and then allegedly obstructed the investigation by concealing documents and encouraging others to mislead federal authorities. The most striking piece of evidence described in that indictment is an audio recording in which Trump is heard discussing classified material and acknowledging that he could have declassified it while president, but could not do so anymore. That is not a courtroom confession, but it is an admission against interest captured on tape. Prosecutors also allege that Trump directed aides to move boxes of documents to hide them from his own lawyers and from investigators, and that security footage corroborates those movements. Witnesses, including individuals who worked directly with Trump at Mar-a-Lago, have reportedly testified about these events. Again, Trump denies everything, but the evidence tells a coherent and damning story without his cooperation. Then there are the election interference cases, which are broader and more complex, but follow the same pattern. Trump insists he was simply questioning election results and exercising his First Amendment rights. Prosecutors, congressional investigators, and cooperating witnesses have described a coordinated effort to overturn an election Trump was repeatedly told he lost. Testimony from senior advisors indicates Trump was informed there was no widespread fraud. Former officials have stated under oath that Trump knew the claims he was promoting were false. Evidence of the fake elector scheme shows how fraudulent certificates were prepared and submitted in an attempt to disrupt the electoral count. Statements and testimonies surrounding January 6 describe pressure on the vice president, awareness of armed supporters, and efforts to exploit chaos to cling to power. Once again, Trump has not admitted any of this in court. He denies it all. But denial does not erase testimony, documents, or recordings. When multiple witnesses independently describe the same conduct, when contemporaneous documents align with those accounts, and when recordings capture the defendant's own words, the absence of a confession becomes largely irrelevant. This brings us to the second half of the story, which is just as telling as the evidence itself, the quiet, relentless departure of lawyers from Trump's orbit. This is not about one dramatic walkout. It is about a sustained pattern of legal professionals deciding that representing Trump is too risky, too unethical, or too legally dangerous to continue. According to reporting from Reuters, roughly two-thirds of the Justice Department unit responsible for defending Trump-era policies in court have left. That is not normal turnover. Government lawyers routinely defend controversial policies without quitting en masse. What makes this different is what some of those lawyers have reportedly said after leaving. They were concerned about being pressured to misstate facts, advance arguments they knew were false, or undermine their own professional obligations to the courts. Lawyers have ethical duties that do not disappear just because a client is powerful, and many decided they could not continue without jeopardizing their licenses and reputations. Trump's private legal teams have experienced similar instability. Law firms have withdrawn. Attorneys have resigned. Others have found themselves indicted for their own roles in Trump-related schemes. Some have become cooperating witnesses, choosing self-preservation over loyalty. Even figures who once served as Trump's fiercest defenders are now facing disbarment or criminal exposure themselves. This is not coincidence. It is the predictable outcome of defending conduct that crosses legal and ethical boundaries. Good lawyers do not abandon strong cases. They do not flee winnable defenses. When experienced attorneys walk away in large numbers, it signals that the defenses available are weak, the evidence is strong, and the risks of continuing representation outweigh any professional benefit. In Trump's case, the exodus of lawyers functions as its own kind of admission. It is legal professionals collectively saying, without saying it out loud, that this is indefensible. Taken together, these two realities form a devastating picture. Trump has not confessed, but the evidence has effectively done it for him. His lawyers have not staged dramatic exits, but they are leaving in droves because staying means risking their careers, their freedom, or both. The documents, recordings, and testimony speak louder than any words Trump could ever utter, and the steady unraveling of his legal teams reinforces what that evidence already shows. This is not about spectacle. It is about accumulation. 1,000 small documented facts building into an undeniable record. And that record is becoming harder to ignore with every witness who testifies, every document that surfaces, and every lawyer who quietly decides they want no part of what comes next. What makes all of this so powerful is that it exposes a fundamental misunderstanding many people have about how guilt is established in the real world. A criminal case is not a morality play where everything hinges on a dramatic confession. It is an exercise in reconstruction. Prosecutors rebuild events using objective evidence, contemporaneous records, and testimony from people who were there. When those pieces align, a defendant's denial stops carrying weight. That is exactly what has happened repeatedly in Trump's legal orbit. Take the classified documents case again because it perfectly illustrates this dynamic. Trump insists that everything he did was lawful, that he had absolute authority, that the documents were his, and that he cooperated fully. But prosecutors didn't rely on opinion or interpretation. They relied on physical evidence and firsthand accounts. They documented which classified materials were taken, where they were stored, who had access to them, and how efforts were allegedly made to conceal them after subpoenas were issued. They collected surveillance footage showing boxes being moved. They gathered testimony from staff members who were instructed to move those boxes. They obtained sworn statements from Trump's own lawyers describing what Trump told them during the search process. When all of that is placed side by side, it paints a picture that is extremely difficult to explain away as misunderstanding or accident. This is why Trump's continued insistence that he did nothing wrong actually deepens his legal vulnerability. In criminal cases, juries are instructed to consider intent. When prosecutors can show that a defendant knew the rules, was told repeatedly what those rules were, and still acted in ways that violated them, intent becomes easier to establish. Evidence that someone attempted to hide conduct or mislead investigators often matters more than the underlying offense itself. Obstruction is powerful because it suggests consciousness of guilt, and the evidence prosecutors have described in Trump's cases consistently points in that direction. The election interference matters follow the same pattern. Trump has framed his actions as political speech and legal advocacy, but prosecutors have assembled testimony showing that many of the people closest to him repeatedly told him he lost the election and that there was no evidence to support his fraud claims. When a defendant continues promoting claims after being informed they are false, that changes the legal analysis. It moves the conduct away from protected expression and toward knowing deception. Add to that the fake elector scheme, which involved creating documents that falsely represented official state actions, and the legal exposure becomes much more concrete. None of this requires Trump to admit wrongdoing. In fact, defendants who refuse to admit wrongdoing, while evidence piles up, often harm themselves in subtle ways. Judges notice, juries notice, even pre-trial rulings can be affected when courts perceive a pattern of dishonesty or bad faith. Trump's pattern of blanket denial, regardless of evidence, has not helped him. It has simply made the contrast between his claims and the record more stark. Nowhere is that contrast clearer than in the behavior of the lawyers who have been closest to these cases. Lawyers are trained to assess risk. They are trained to evaluate evidence. They are trained to understand when a defense strategy is viable and when it crosses ethical lines. When large numbers of lawyers independently reach the conclusion that continuing representation is dangerous, that assessment carries weight. This is especially true of the Justice Department attorneys who resigned or transferred out of units defending Trump-era policies. These were not political opponents parachuted in to sabotage an administration. These were career professionals whose job was to defend government actions. When they conclude that continuing would require misrepresenting facts or advancing arguments they believe to be false, their departure becomes an indictment of the situation itself. Lawyers are obligated to zealously represent clients, but they are also officers of the court. That duty to the legal system does not disappear, and many chose it over continued association with Trump. The same pattern appears in Trump's private legal teams. Early on, Trump was represented by high-profile firms with deep experience in complex litigation. Over time, those firms withdrew, citing conflicts or other reasons, and Trump increasingly relied on smaller teams or lawyers willing to take risks others would not. Some of those lawyers have since faced sanctions, disciplinary proceedings, or criminal charges themselves. Others have flipped and begun cooperating with investigators. That evolution does not happen in cases where the client's position is strong and defensible. It happens when exposure grows and loyalty becomes liability. It is also important to understand that lawyers do not flip lightly. Cooperation agreements usually require admitting wrongdoing and testifying truthfully. That is a last resort for people who believe the alternative is worse. When former allies choose cooperation, they are signaling that prosecutors possess substantial leverage. That leverage usually comes from documents, recordings, and corroborated testimony. Again, the evidence is doing the talking. Another overlooked aspect of this story is how these developments interact. Each cooperating witness strengthens the case against remaining defendants. Each document authenticated at trial becomes harder to dispute in later proceedings. Each judicial finding of misconduct or contempt adds to a record that future judges will see. Legal cases do not exist in isolation. They accumulate context. Trump's refusal to acknowledge any wrongdoing does not erase that context. It amplifies it. This is why the narrative that Trump is simply being persecuted by hostile prosecutors fails to hold up under scrutiny. Persecution narratives rely on the idea that accusations are unsubstantiated or politically motivated. But when convictions occur, when documents are authenticated, when recordings are played in court, and when insiders testify under oath, the argument shifts. At that point, the debate is no longer about whether something happened, but whether the defendant should be held accountable for it. The Manhattan verdict already answered that question once. The jury was not confused. They were not split. They convicted Trump on every count. That outcome did not require Trump to admit anything. It required prosecutors to prove their case, which they did. The same model applies to Trump's remaining legal exposure. Whether or not trials proceed immediately, the evidentiary foundation has already been laid. What makes the lawyer exodus so telling is that it reflects how professionals closest to the facts see the situation. These are not commentators speculating from a distance. These are people who reviewed documents, sat through interviews, evaluated discovery, and assessed legal risk. Their collective decision to walk away is itself a form of judgment. This is why focusing on whether Trump personally admits guilt misses the point. Admissions matter far less than records. Words matter far less than corroboration. And loyalty matters far less than survival when legal consequences become real. Trump's legal story is not one of sudden collapse. It is one of gradual exposure, where each new piece of evidence makes denial less plausible, and each departing lawyer makes the defense weaker. By the time cases reach juries, narratives have already been shaped by months or years of pretrial rulings, motions, and disclosures. Judges form impressions, prosecutors refine theories, defendants reveal patterns. Trump's pattern has been consistent. Deny everything, attack everyone, and hope delay outlasts accountability. That strategy may buy time, but it does not erase evidence. What we are seeing now is the cumulative effect of that evidence. The documents are permanent. The recordings are preserved, the testimony is on the record, and the lawyers who once shielded Trump are increasingly choosing to protect themselves instead. That combination is far more dangerous than a single dramatic courtroom moment because it builds an enduring factual record that does not disappear when headlines move on. This is why the endgame of Trump's legal situation isn't about whether he ever utters the words, "I'm guilty." It's about whether the legal system ultimately treats the mountain of evidence in front of it the same way it treats evidence in every other serious criminal case. And right now, the trajectory points in one direction. The record is getting thicker, not thinner. The witnesses are multiplying, not disappearing, and the defenses are narrowing, not expanding. One of the most damaging aspects for Trump is that his strategy relies heavily on time rather than substance. Delay has always been his primary legal tool. Appeal everything, challenge jurisdiction, attack prosecutors, question legitimacy, hope elections, appointments, or procedural complications intervene before final judgments arrive. That strategy can work for a long time, especially for someone with money, power, and influence. But delay does not negate evidence. It only postpones the moment when evidence is weighed. What makes this moment different from earlier controversies in Trump's career is that multiple independent systems are now producing the same conclusion. Juries have convicted him. Judges have sanctioned him. Former allies have testified against him. Lawyers have withdrawn. Institutions that once insulated him are now documenting his conduct rather than defending it. That convergence matters. It's how accountability actually forms in complex cases involving powerful figures. Trump's refusal to acknowledge reality also creates a paradox for his defense. By insisting that everything is a witch hunt, he forecloses nuanced explanations that might otherwise mitigate damage. There is no admission of mistake, no acknowledgement of overreach, no attempt to separate reckless behavior from criminal intent. Everything is framed as total innocence or total persecution. That absolutism might energize supporters, but it is poison in courtrooms. Courts operate on credibility, and credibility erodes when every fact, no matter how well documented, is dismissed as fake. This erosion shows up in subtle but important ways. Judges become less patient with frivolous motions. Prosecutors become more confident in seeking aggressive rulings. Defense teams become more constrained in what arguments they can ethically advance. Each step tightens the space in which denial can operate. Trump's legal world has been shrinking for years, even as he projects strength publicly. The collapse of his legal teams underscores that reality. Lawyers do not abandon clients lightly, especially high-profile clients who can pay well and offer visibility. When they leave, it's because the cost-benefit calculation has flipped. The reputational risk, the ethical exposure, and the potential for personal legal consequences outweigh any upside. That calculation is being made again and again by people who understand the stakes better than anyone watching from the outside. And that is why the metaphor of Trump admitting crimes resonates, even if it's not literally true. The system is treating the evidence as sufficient. The witnesses are speaking under oath. The documents are authenticated. The paper trails are intact. At a certain point, denial stops being a defense and becomes part of the proof. It demonstrates intent, awareness, and refusal to correct unlawful behavior. This also explains why Trump's attacks on prosecutors, judges, and lawyers have intensified rather than diminished. They are not signs of confidence, they are signs of narrowing options. When legal arguments fail, defendants often turn to political arguments. When political arguments fail, they turn to intimidation. None of that changes what is already in the record. What happens next does not hinge on a single dramatic moment. It hinges on whether remaining cases proceed, whether appeals succeed, and whether future juries see the same pattern earlier juries have already seen. It hinges on whether delay continues to work or whether time finally runs out. Trump's denial strategy only functions as long as institutions hesitate. Once institutions act, denial becomes irrelevant. The most important thing to understand is that accountability is rarely cinematic. It is incremental. It is boring. It is built through filings, testimony, rulings, and precedents. Trump's legal exposure has followed that exact path. Each small development has reinforced the last. Each quiet resignation has spoken louder than a speech. Each cooperating witness has done more damage than any headline.